Welcome back to Good Law, Bad Law. When it comes to climate change, the big question now seems to be not so much is climate change a real thing, but what do we do about it? And as I'm fond of saying on this podcast, the law really does matter. And this episode is all about how the law matters when it comes to climate change. In a New York City courtroom this week, the New York Attorney General is putting on trial the biggest and baddest fossil fuel company in the world, Exxon Mobil, for defrauding its investors over climate change. And inspired by that, and 2 days later, just yesterday, the Massachusetts Attorney General filed an even broader lawsuit in a Massachusetts state court against Exxon Mobil, arguing that it has violated state consumer protection laws with its role in fomenting, creating, and spreading disinformation about climate change. My guest, one of the leading environmental lawyers literally in the world, Michael Gerrard, a law professor at Columbia Law School, someone who's practiced in environmental law for 3 decades, raising a new generation of lawyers at Columbia to go out into the world to take on the issue of climate change at the federal, state, and local level, as well as in many environmental, non-governmental organizations and nonprofits. We talk about the case in New York City and in Massachusetts, what these cases are about, how they fit into the broader action on climate change. And it's a fascinating conversation, a very important one. I think it opens a new front on the whole issue of what we can do and what lawyers can do and what everyone should know about what lawyers are doing on the issue of climate change. So a great conversation with Columbia Law Professor Michael Gerrard. Stay tuned. While much of the news in the last several weeks has been focused on Washington and the impeachment inquiry, this week there are events taking place of potentially even more global significance, if that's even imaginable. In a New York City courtroom, the New York Attorney General has begun a case against Exxon Mobil, the claim being that they have been lying to investors about the impact and costs of climate change. And with me to discuss this and this new front in the discussion and fight regarding climate change, that new front being cases taking place in courtrooms, not just in New York City, but prominently in New York City. This case is probably going to be a bellwether for many other courtrooms across the country, many other attorney general's offices. With me to discuss this, its significance, and where we've been and where this is taking us is my guest today, Michael Gerrard, the Andrew Sabin Professor of Professional Practice at Columbia Law School, a graduate of Columbia College, my alma mater, and arguably one of the most influential and important environmental lawyers in New York City and beyond. So first of all, Michael, thank you so much for being on Good Law, Bad Law.
Good to talk to you, Aaron.
We're going to talk about this New York trial that has just started this week, but give us a little background on yourself first, and and what you do at Columbia and how you got to be doing all that you do in the area of climate law.
Okay. Well, I practiced environmental law with private law firms in New York City for 30 years, most recently as the head of the New York office of Arnold and Porter. But in 2009, I became a member of the full-time faculty at Columbia Law School and became senior counsel at Arnold and Porter. But at Columbia, I teach environmental law and energy regulation and climate change law. And I also founded and direct the Sabin Center for Climate Change Law, whose purpose is to develop legal techniques to fight climate change, to train the next generation of lawyers to use those techniques, and to create and post legal resources for use by lawyers, judges, scholars, and students around the world.
Well, and that's a good lead-in, because I think, so many people, when they think of action on climate change and the issue of climate change, think about the scientists, that have been warning about the perils of climate change since the 1970s. Many think about the recent protests of young people and students literally all across the world, like Greta Thunberg. And I'm proud to say my own daughter, who's a college student at Tufts and is involved in a group called Sunrise, which is one of the young people organizations that has been leading the charge on the student climate strikes over the last bunch of weeks. But I think people may not know as much about the efforts to tackle climate change and those responsible for climate change that are taking place in courtrooms now with this bellwether trial in New York City against Exxon Mobil. Give us, if you would, the background for this case so that we can understand what the issues are at trial taking place this very week.
So the New York State statute on securities disclosure, its blue sky law, is called the Martin Act. And the Martin Act gives the New York Attorney General extensive authority to investigate and go after securities fraud. So several years ago, the Attorney General of New York announced an investigation of Exxon. The initial impression that most people had about that investigation was that it was going to be looking into Exxon's prominent role in fostering denial of anthropogenic climate change, while at the same time its own scientists were telling Exxon that climate change really is a serious problem and it's mostly caused by fossil fuel emissions. So most people thought the investigation was going to focus on that fairly broad issue. The New York Attorney General got extensive discovery from Exxon, pre-lawsuit discovery, which the Martin Act allows it to do. And they filed at last their lawsuit last year, which is much more narrowly focused. It's focused on Exxon's use of a proxy cost of carbon, a device in accounting to say that if we were to internalize the externalities, if we were to account for the negative impacts that climate change has, what are the impacts on Exxon's decision making and so forth. So the lawsuit is alleging that Exxon used different numbers in different contexts, and they allege that Exxon fraudulently misled shareholders about how they were doing that, and that it alleges they were functionally keeping two sets of books. So that's the focus of this particular lawsuit.
Why is it that and this was the former New York Attorney General who began this investigation, right? And had some.
It started under Eric Schneiderman, and then Barbara Underwood, and now Letitia James.
Well, and it did start with sort of broad promises of taking on the biggest and baddest of the fossil fuel companies, Exxon Mobil, and its role in causing climate change. What is your understanding as to why that broader legal challenge to Exxon's role had to be more narrowly focused as it now is in the trial taking place in New York City?
Well, I don't know that I'd say that the investigation began with these broad promises. A lot of people assumed that that's what they would do, but I think they just looked at the evidence that they were able to obtain and felt the clearest, strongest, sharpest case was on this proxy cost of carbon. The
reason I guess I asked that is one of the articles that I was reading about the New York City trial talks about Eric Schneiderman in 2015 talking about how he wanted to get into the issue of how Exxon and some of the other big oil and fossil fuel companies hid their knowledge going back decades of their role in causing climate change, and that was even if the legal theory that had to be pursued in court ends up being more narrow in the sense that it's a securities fraud a case, really. It's a defrauding of Exxon's investors case, but that was the motivation behind the effort and the investigation that launched this whole project.
Well, and one of the arguments that Exxon has repeatedly made in its numerous and ultimately unsuccessful efforts to prevent this case from going to trial is that the lawsuit was politically motivated. That was one of the claims that they were making, but the courts have not found that to be relevant to whether the New York Attorney General may in fact bring this case.
So to understand what exactly the theory is that they're pursuing, the nature of the fraud here is that they are essentially under accounting for the costs the company will experience in the future because of what? Regulations that will be imposed, taxes, carbon taxes that might be imposed because of is that what it really is?
So in the first place, it's a matter that the complaint alleges that Exxon claimed that it was, accounting for various climate risks to a particular extent, and that they did that sometimes but not other times, and so didn't reflect it in their decision making. So one particular example is that the complaint claims that Exxon invested heavily in Alberta tar sands, which are under some calculations especially greenhouse gas intensive, but had it accounted for the climate impacts of the tar sands in the way that Exxon said it would, they could have come to a different decision on whether to invest in Alberta tar sands. So the exposure of Exxon is partly there could be regulations that are imposed that restrict the use of fossil fuels. There could be carbon taxation. There's also the physical impact that climate change itself has on Exxon's facilities and operations.
So this case is in New York City has been described as potentially being a bellwether, meaning other attorneys general and in other states may follow the lead that this case is setting. And in fact, no sooner did the trial start than the Massachusetts Attorney General filed what seems to be a fairly similar lawsuit in a Massachusetts state court in Boston under a somewhat different theory. What can you tell us about that case?
So that case that the Massachusetts Attorney General Maura Healey filed yesterday is actually considerably broader than the New York case.
Mm-hmm.
The Massachusetts case is not just focused on the proxy cost of carbon, but looks more broadly at what Exxon knew about climate change and what it was saying at the time, and saying there was a contrast between what it knew and what it said. So the Massachusetts AG is taking it has a strategic is adopting a different strategy and is doing much more broadly.
Yeah, and again, this case as well as the New York case encountered, as one might expect, intensive resistance from Exxon and all kinds of pretrial maneuvers in court to try to prevent the case from going forward. And in the account that I read this morning, literally hours after a court ruled that the Massachusetts case could proceed, they filed a more than 200-page complaint, which I admit I didn't quite get all the way through this morning, but I read the first bit of it. We'll post a link to it because it's fascinating. Reading on the role Exxon has played in really, the disinformation campaign they've engaged in going back decades. Something that in the Massachusetts complaint, the Attorney General compares to the tobacco industry's long denial campaign regarding the dangerous impact of cigarette smoking. But a very different legal approach, as well as a broader approach, as you point out, in the Massachusetts case, in that, as I understand it, the Massachusetts case is invoking state consumer protection law rather than securities fraud law as the basis for that action. Is that right? What can
the Massachusetts and New York statutes are somewhat different, and so Massachusetts is using a separate different theory. Let me just add that Exxon sued the Massachusetts Attorney General in Massachusetts State Court to try to block the investigation, and that went all the way up to the Supreme Judicial Court of Massachusetts, which affirmed the dismissal of the challenge, and the U.S. Supreme Court refused to review it. So there's been a lot of litigation about the Massachusetts investigation, as there has been in New York. The Exxon sued the New York Attorney General in the Federal District Court for the Southern District of New York to try to shut down that investigation. The Southern District rejected that suit, and that is now up on appeal to the Second Circuit, but no stay was issued, and so the trial is happening.
Well, and one of the, as I understand it, one of the challenges Exxon tried to bring in terms of the Massachusetts case was arguing that this was a case of selective prosecution, which sounds a little bit like tiny violins. What are you picking on poor Exxon for? But there really is a legal theory of selective prosecution. Ultimately, they were unsuccessful in that challenge. But I gather what they're saying, or what they were trying to say, was you're picking on Exxon, but there's lots of other companies, and that suggests some kind of political agenda here rather than of a valid claim. Is that what's behind the idea of a selective prosecution type argument?
I suppose that's what they're trying to claim, but Exxon, of the publicly traded companies, is far and away the most prominent in fostering climate denial. So there was a rational basis for selecting them.
Well, and this issue of the comparison to the tobacco companies I find so fascinating, and I don't know that many people fully appreciate the facts that have been developed. There's even right up to the president, who is at times called climate change a hoax, and we hear about the efforts to discredit the overwhelming majority of climate scientists who talk about the real science behind climate change. But I think probably most people don't fully appreciate the role Exxon has played over now many decades, as the tobacco companies did for many decades, in creating a climate, if you will, of doubt about the reality, about the real facts of climate change. Can you tell us, because as I understand it, the investigation by these two attorneys general and also by certain news media outlets to bring out the truth about Exxon's role has been pretty successful, actually, in creating an actual factual record of Exxon's role. Can you say a bit about that?
Yeah, it's been known for some time that this phenomenon has been happening. Naomi Oreskes, who's now a professor at Harvard, and Eric Conway wrote a classic book called The Merchants of Doubt, which is about how this was done with climate change, with tobacco, with various other industries. But a couple of years ago, Inside Climate News and the Columbia School of Journalism, working with the LA Times, produced extensive investigations of the role that Exxon played, and then the discovery that the New York Attorney General had in this case has come up with even more. But that Exxon was a major funder of a number of these organizations that were putting out climate denial propaganda. So they really played a major role. And the rise of the climate denial movement, which really took off around 2009, played a major role in the defeat in the United States Congress of climate legislation, and in the in what's happened in the U.S. and some other countries since then, in batting down the necessary climate regulation and legislation.
And it's fascinating to me too, because of course we live in a world today of social media and fake internet bots and that we're so concerned about whether it's in the way interference can be done with our election process, whether it's anti-vaccination the people who are spreading disinformation about vaccinations. And here, because this goes back decades to a time before the internet, in fact, but now with the internet and with social media, the potential for sowing the seeds of doubt based on false facts, false science is so great. What do you see a role for these trials? Now the case in New York City is actually in a courtroom, and this evidence is going to come in as evidence in an actual trial with a court record. Do you see a role for this trial beyond the legal theory of investor fraud, of securities fraud, in the case of the New York City case? Do you see a role in sort of creating a factual record about which there can actually be no doubt once that record is created?
Well, it's certainly shining a light on what has happened, but I have to say that it's hard to have genuine doubt about the fundamentals of climate science, even without this, given the great mass of scientific studies, the authoritative studies that have been done by the Intergovernmental Panel on Climate Change, by multiple U.S. federal agencies under the National Climate Assessment, by the U.S. Defense Department, up and down the line. There is just exhaustive evidence in many, many records about the reality of climate change. And one thing I want to say is that, so far as I can tell, not a single court decision anywhere in the world has cast doubt on climate science. There have been several attacks. All of them have been unsuccessful. There are, several other cases where the courts have just dodged the issue. But no climate denier has ever convinced a court that they're right. In the political forum and certain news networks, you hear a lot of doubt. But people are no longer challenging the reality of climate science in the courtroom. Exxon is certainly not challenging climate science in this case.
Right. They have come a long way in their own corporate evolution from the 1970s, when they were denying, even though they had the scientific knowledge of their contribution and the contribution of fossil fuels to climate change. They've come a long way in their own corporate communications regarding climate change itself. Well, but so let me then switch to the question of what do we do about climate change? Because there does seem now, except for perhaps climate deniers who I think at this point are legitimately on the fringe of our politics. The Democrats 4 years ago and the Republicans 4 years ago, nobody was talking in the political campaigns or in the primaries about climate change. I don't think there was a single mention of climate change in any of the debates in the last presidential election cycle. And now it does at least come up as a topic of discussion. We now talk about a Green New Deal. We know that private industry is taking a much more active role in looking for ways to reduce carbon footprints. We see young people taking to the streets in the hundreds of thousands all across the world. So people are very much more active, it seems, in trying to answer the question, okay, what do we do? What do you see as the role of these cases in terms of answering the question, what do we do about climate change? Is it about holding companies like Exxon accountable for their past conduct? Is that part of the answer to what do we do about climate change?
Well, that's part of the political narrative, but my own view is that the real focus ought to be on the substantive actions in in decarbonizing the economy and moving away from fossil fuels. Combustion of fossil fuels is responsible for 80% of the greenhouse gas emissions in the United States. The two largest sources of fossil fuel combustion and greenhouse gas emissions are the transport sector, cars and trucks and buses and so forth, and electricity generation. So far and away, the most important things that can be done to fight climate change are to move away from the internal combustion engine in transport and to move away from fossil fuels to generate electricity. So there are many actions that can be taken along those lines that have a direct impact on greenhouse gas emissions, and that's a much more direct way of fighting climate change than the actions that have more of a sort of political resonance, such as the prosecutions of the companies for disclosures or otherwise.
Well, how then do these two cases, and there will certainly be others. I mean, I've read that Baltimore, the city of Baltimore is looking into, or maybe further along than just looking into, bringing a similar action, and other attorneys generals are obviously going to be keeping a close eye on what happens in New York City and what now is happening in Massachusetts. Though in the New York City case, it's about securities and investor fraud, and in Massachusetts, it's about consumer protection. Do those actions fit into the broader prescription that you're describing? In other words, if the biggest of the big, Exxon Mobil, is held to account, so to speak, for its role as a fossil fuel company, is there a role for these cases, or do these trials fit into that broader prescription that you're describing of reducing our carbon footprint in terms of combustible fossil fuels?
Well, they're certainly bad for the reputation of Exxon, and they delegitimize the company and may weaken it somewhat politically, but it doesn't have a direct impact on greenhouse gas emissions. So it's a couple steps removed from something that has a direct impact.
Well, tell us a little bit, Michael, about the Sabin Institute, because you mentioned too that part of the work you're doing at Columbia is raising the next generation of lawyers who will be involved in who will be involved as lawyers in climate change action. What specifically are the types of activities you're working on, and what do you think that this next generation of lawyers who are coming along through Columbia and other programs around the country, what role do you see them taking in climate change action?
So quite a few of our graduates, people who've gone to Columbia Law School and taken my climate change class and environmental class, have gone on to work at organizations like Earth Justice and Natural Resources Defense Council, Environmental Defense Fund, the Center for Biological Diversity, other groups that are very active, the Sierra Club, other groups that are extremely active in the legal fight on climate change. And that legal fight takes place in many different fora. There's a lot happening in Congress, in the state legislatures, in some city councils, in the congressional committees, state legislatures, private enterprise, the construction of renewable energy facilities. There's just a whole host of legal work that is associated with trying to reduce greenhouse gases, and there's an additional host of legal work that hasn't taken off to the extent that it needs to in coping with the impacts of climate change, with coping with the things that are going to happen regardless of what we do to reduce greenhouse gases. We're seeing that starkly now with the horrible situation in California with the wildfires, right, and the PG&E cutoff of power, which are just a sort of a foretaste of what may come in the future.
Yeah, I was just talking to my dad about that yesterday. He lives in San Francisco, and they're very worried about. It seems now every year these the fires in California become worse and worse, and it's not just property damage; it's destruction of the environment. It's very worrisome, and other manifestations of climate change as well, of course. So, this administration has not done very much, and I know I read this week that the president is talking about finalizing or formalizing the withdrawal of the U.S. from the Paris Climate Accord, something that he announced he would do, but as I understand it, it is somewhat confusing. That hasn't actually formally taken place. How important do you think it is that the U.S. be part of that effort, and how damaging do you think it is if the U.S. pulls out of that international agreement?
Well, the U.S. is historically the largest emitter of greenhouse gases. China has overtaken us on an annual basis, but the load of greenhouse gases in the atmosphere is more from the U.S. than from any other country. Many other countries say, well, if the U.S. isn't acting on climate change, why should we?
Yeah.
So the current U.S. stance is really inhibiting global action. As a legal matter, the way the Paris Climate Agreement is written is that there's a several-year notice process before a country can withdraw, and the U.S. the first day that the U.S. can withdraw from Paris actually is the day after the 2020 presidential election. And
well,
so if that election yields a Democratic president, he or she will almost certainly announce immediately, well, we're still in.
Yeah.
So the Paris Agreement was intentionally non-binding in most ways, and so being in it or not has a lot of political significance, but it's not the be-all and end-all.
But you do hear this argument in political circles and pundits on TV and in pundit-oriented podcasts and the like. Why should the U.S. take on unilaterally so much of the burden its people? This is often an argument raised in opposition to the notion of a Green New Deal. Why should the U.S. make all these sacrifices? It's not going to make any difference unless China and India and other big carbon-emitting countries also get on board, and they're not getting on board. But
all of that is completely false.
Okay.
It's all completely false. In the first place, in order to successfully cut back on climate change, we need action by the U.S. and China and India and every other industrial and industrialized country. Regardless of what any other country does, unless the U.S. radically reduces our greenhouse gas emissions, there's no way that we meet the Paris temperature targets. The U.S. has to act. The per capita emissions from the U.S. are the highest in the world. Australia and Canada are in the same place, and then Saudi Arabia, but they're a different case. So our greenhouse gas emissions per capita are considerably higher than those of Europe and other industrialized countries. And China's are rising, but they're still far below that of the U.S. So the U.S., frankly, has a lot of nerve saying, why should we act if China isn't? Because we're consuming so much more energy and producing so much more per capita. India is just a fraction of China. India's per capita emissions are minuscule now on a per capita basis.
Yeah. Now they have a lot more.
The atmosphere will care fundamentally about the future economic growth and the energy patterns of India and China and other places, but none of that is an excuse for the U.S., the world's historically largest greenhouse gas emitters, not to act.
Well, and beyond that is the point you made before too. Is the U.S. going to be a leader on this issue or not? And by pulling out of, or announcing an intention to pull out of the Paris Agreement and failing to take other steps that demonstrate leadership on this issue, that does send a signal to other countries. Why should we get engaged on this if the United States isn't going to?
Well, we're the opposite of a leader. We're a drag. We're pulling down international action.
Well, Michael, thank you so much. This has been a great conversation. Thanks for helping us understand these cases. I think we should keep a very close eye on what is going to happen in this New York City courtroom as that trial proceeds, and what will happen as the Massachusetts Attorney General moves forward with her case in state court there, arguing consumer protection, and I assume seeking very substantial damages from Exxon in both of these cases. I mean, the damages could run into the hundreds of millions or even billions of dollars, something that Exxon, I think, can afford since they made about $20 billion in profits last year. But we should keep a very close eye on that. And also, I will, in the description of this episode, Michael, post a link to the Sabin Center so people can learn more about what you're doing at Columbia, the work you're doing there, and also links, of course, to these two cases that we've been talking about. So thank you so much. I really appreciate you being on Good Law, Bad Law today.
May I add one more thing about the role of lawyers here?
Yes, please, of course.
So let me just quickly say that several years ago, an important set of engineering studies was done called Pathways to Deep Decarbonization, which looked at what physically the U.S. and other countries could do to greatly reduce their greenhouse gas emissions. Another law professor, John Dernbach, and I then put together a book called Legal Pathways to Deep Decarbonization of the United States, which addressed the question, how can U.S. law, federal, state, and local, change in order for the U.S. to be on that pathway? So this past April, the Environmental Law Institute published a 1,200-page book, Legal Pathways to Deep Decarbonization in the United States, which John Dernbach and I edited. It had 35 chapters written by a lot of different lawyers and law professors with more than 1,500 recommendations for specific action.
Wow. Our
new project is to recruit pro bono law firms to draft the model laws that are recommended by the book. And so far, about 20 big law firms have volunteered to undertake this pro bono drafting project. This pro bono project is being coordinated by a fellow named Rick Horsch, who recently retired as an environmental partner at White & Case. And so any lawyers out there who might be interested in joining up, Rick Horsch, formerly of White & Case, would be a good person to contact.
So these model laws that you're talking about, all these firms and hopefully many more as well will help draft based on the recommendations in the book that you edited. These will be model laws then that federal, state, and local legislators can use to create laws in their jurisdictions?
Exactly right. They'll take the models, they customize them to their own jurisdiction, and hopefully enact them.
Well, that's great. So for all the lawyers who are listening to the program, pay attention. We'll also put a link to Michael, your book that you mentioned, so people can take a look at that, and also encourage people. Do you give us the name of the White & Case attorney you wanted to mention again?
Richard Horsch, Horsch.
And can they reach him at White & Case still, or what's?
Yes, and I'll send you some links you can post on.
Yeah, that would be great. We'll include those as well in the description, and of course, any non-lawyers, and we do have many non-lawyers who listen to the program. I encourage you as well to take a look at this so you can understand better how, as I am always fond of saying, how the law matters and really can make a difference. And Michael and your program at Columbia are doing just that. So again, Michael, thank you very much for being on the podcast. I appreciate it.
Thank you, Aaron. I enjoyed it.